Bateman, and this is the Privacy Corner with Privado AI. So this week I'll be looking at whether President Trump's firing of 2 FTC commissioners and a few other things he's done could end up undermining transatlantic data flows. A court in Luxembourg has finally upheld a complaint submitted against Amazon in 2018 that resulted in what was at the time the largest ever GDPR fine, and Meta has settled a case that allows one UK user to opt out of targeted ads. So on the 19th of March, Trump fired Federal Trade Commissioners Alvaro Bedoya and Rebecca Slaughter. So how could this, plus some of Trump's other actions, impact data flows between the EU and the US? Now, Bedoya claims that his dismissal is illegal under the FTC Act and that he would see the president in court. There is a legal precedent that suggests that Bedoya could be right, that what Trump has done here is indeed illegal. In the 1935 Supreme Court case, Humphrey's Executor versus the United States, the question came up of whether the president can fire commissioners before the end of their statutory term. And the court decided that no, the president cannot do so, except for the reasons set out in the relevant statute. In that case, and this one, the FTC Act, which includes negligence and malfeasance in office. But firing Commissioners Bedoya and Slaughter is not the only action Trump has taken that could put EU adequacy under threat. In January, he dismissed 3 Democrat members of the Privacy and Civil Liberties Oversight Board. That leaves only 1 member remaining. The board's quorum is 4, meaning that it's currently left unable to function. Now, the PCLOB oversees the Data Protection Review Court. This is a key element of the EU-US data privacy framework, and the court was established to address a key weakness of the DPF's predecessor framework, Privacy Shield, which was shot down by the CJEU in 2020 due to a lack of an independent redress mechanism. And on the 18th of February, Trump issued Executive Order 14215 called Ensuring Accountability for All Agencies, which aims to, quote, ensure presidential supervision and control of the entire executive branch. So EO 14215 prohibits independent regulators from interpreting the law in a way that contravenes the President or the Attorney General's opinion. And the order also requires agencies to appoint a White House liaison and to submit strategic plans for clearance by the White House's Office of Management and Budget. The order also requires heads of regulatory agencies to comply with performance standards and management objectives issued by the Office for Management and Budget, and to report periodically to the President on their performance and efficiency in attaining those standards. So this all, of course, undermines rule of law in the US, which is a key element in the country's adequacy decision. So far, the reaction across the Atlantic has been muted. We've had some statements from the Scandinavian data protection authorities, and also on the 13th of March, European Commissioner Michael McGrath said that the Commission is committed to the full implementation and enforcement of the EU-US DPF. There is a case coming up on April the 1st from French MP Philippe Latombe, but I think that case against the DPF has some procedural issues and might not succeed, but I'll be sure to let you know. Now, next up, Amazon has lost a court battle against a €746 million, that's around $812 million fine, issued by the Luxembourg Data Protection Authority. So this decision relates to a complaint submitted nearly 7 years ago, by the non-profit LQDN and over 10,000 data subjects. But until the administrative court published its judgment last week, very little was officially revealed about this case. That's thanks to Luxembourg's commercial secrecy rules. The penalty was actually first revealed not by the DPA or the court, but by Amazon itself, which declared it in a 2021 filing with the US Securities and Exchange Commission. So, among other findings, the court upheld the Luxembourg DPA's allegations that Amazon failed to get consent for targeted advertising cookies. They were relying on legitimate interests. violated the GDPR's transparency rules under Articles 12 to 14, failed to uphold data subjects' rights requests. They said that they did not have to because the personal data had been pseudonymized. Now, in its defense, Amazon gave some complex procedural arguments, including that the legal process violated their right to a fair trial under Article 6 of the European Convention on Human Rights. The court essentially found that because the Luxembourg DPA was not a tribunal, it had the power to impose the sanction on Amazon, and it dismissed these procedural arguments. As such, the case stands, and it's an important reminder of the interplay between the EU's e-privacy rules and the GDPR. Finally, Meta will allow one person in the UK, campaigner Tanya O'Carroll, to opt out of targeted ads on Facebook and Instagram following a settlement reached days before a scheduled court hearing. So the settlement is between O'Carroll and Meta. Meta has agreed to honour O'Carroll's request under the right to object and will no longer process her personal data for the purposes of targeted advertising. Currently, UK Facebook and Instagram users are not offered a means to avoid receiving targeted ads on the platforms, unlike in the EEA, where users can opt to pay a subscription fee rather than accepting targeted ads. Now, while the settlement only affects O'Carroll, she says it represents a victory for everyone who values their fundamental right to privacy. And it shows that if other people want to exercise their right, she believes they now have a great way to do so, knowing that the UK regulator, the ICO, will back them up. She said this to the BBC. Meta disagreed that the settlement applied so broadly, stating that no business can be mandated to give away its services for free. Now, the UK DPA, the Information Commissioner's Office, actually intervened in O'Carroll's case, offering its views on whether Meta had to comply with data subjects' right to object. A statement from the ICO, included in the court filing, said that online advertising targeted at particular individuals constitutes direct marketing, and that O'Carroll had the absolute right to object to such activities. In a statement published last Friday, the regulator reiterated its kind of general views on the issue, said it would continue to engage with Meta, and that people could file a complaint if they believed their personal data was being processed unlawfully by any company. But it looks as though Meta might be considering switching over to consent or pay in the UK, as it did in the European Economic Area. We know that the ICO, broadly speaking, approves of that model, so I would wait to see how Meta moves before submitting a complaint. So that's all from me this week. A big thank you once again to Privado AI for their support, and I'll see you next time.